Are you facing felony charges and you're not sure how this case is going to look? My name is Carl Birkhead. I'm an attorney with Wirth Law Office in Tulsa, Oklahoma. I've been practicing criminal law for about 7 years now, and I want to help you make law easy by just describing to you what a felony case looks like. So, felonies and misdemeanors are different in a couple ways, but here's the biggest one. A felony is kind of a two-part act. So, first part, you're going to start with your arraignment. You show up at court, you tell the judge, I plead not guilty, and the judge is going to give you a new court date. Sometimes it's going to be for what's called a pre-preliminary hearing announcement, and one day, probably before I retire, I'll be able to say that without stuttering. Or they're just going to go ahead and set you for a preliminary hearing. They'll set it out far enough, or they'll give you the PPH date to give you some time to work with your attorney, to get with the state, and see if there's any way a resolution can be reached without going to trial. Usually this is when your lawyer is going to be trying to do discovery, getting some information from the state, going over the possible negotiation options for whether or not you're going to be able to enter a plea. Those happen usually at this stage, in the first act of the play. If that doesn't work, if for whatever reason you aren't able to get a dismissal or you're not able to get a plea offer that is something that you like, then you're going to reach the resolution of that act, which is called preliminary hearing. At this stage, the state has to put on a case to show that it's more likely than not that a crime was committed by you within that jurisdiction. That the burden of proof is very low. It's preponderance of the evidence. It's basically 51-49 more likely that you did it. The burden is so low here that the state usually, I say usually because sometimes they don't, but more often than not, in my experience, the state meets their burden of proof in the eyes of the court, and then you get bound over to the district court level. This is the second act of the play. Now, this is a really important time because this is the time when you're going to be looking at going to jury trial, which means that you're going to be looking at also having to pay your jury trial fee to your attorney. So you got to keep that financial aspect in there also. At the district court level, you're going to do an arraignment again. You're going to go in front of a different judge. You're going to say, hey, I plead not guilty. After that time, your lawyer is going to do some motion practice to try to suppress evidence, to try to get the case dismissed the hard way, or not the hard way, but instead of negotiation, they're going to try to get the court to dismiss it over the state's objection. And if that's not able to work, or if that just doesn't work out, you're looking at jury trial at that point. That's the conclusion of the play. That's when you and your lawyer, you show up, you select 12 jurors, and you put on your case. You let the state put on their case, and you put on your defense, whatever the defense is. And the state has to prove you guilty beyond a reasonable doubt. If you're in a situation where you're facing felony charges and you're not sure what you're looking at, or you're not feeling great about it, or you need some help, give us a call. My name is Carl Birkhead, and I want to help you make law easy. Thank you.